I have presided over thousands of cases in my career, and if there is one thing that never ceases to amaze me, it is the sheer audacity of a con artist who believes he is the smartest person in the room. People walk into my courtroom every day thinking they can outsmart the system, outsmart the plaintiff, and most foolishly, outsmart me. But there is a specific brand of arrogance that I find particularly fascinating, the kind that hides behind expensive suits, glossy briefcases, and heavily worded contracts. The kind that assumes a judge simply won't take the time to read the fine print. That was the exact kind of arrogance Richard Sterling brought into my courtroom on a brisk Tuesday morning. Richard was 45 years old, the owner of a boutique auto leasing and financing company, and he carried himself with the smug certainty of a man who had never been told no. He wore a tailored navy suit, checked his gold watch repeatedly, and treated my bailiff as if he were a valet. He didn't just walk to the defendant's podium, he glided, flashing a condescending smile at the woman sitting across from him. That woman was Eleanor Vance. She was 68 years old, a retired school teacher, and a widow living on a fixed pension. Eleanor sat at the plaintiff's table with her hands tightly clasped over a worn manila folder. She looked small, frightened, and utterly exhausted. The contrast between the two was stark, and it was a dynamic I had seen countless times before. The predator and the prey. Richard looked at Eleanor not as a human being, but as a minor nuisance he was about to swat away with a wave of his hand and a stack of legal jargon. He believed his paperwork was his shield. What Richard didn't realize, however, was that in my courtroom, the illusion of power evaporates the moment you swear to tell the truth. He thought he had built an impenetrable fortress of clauses and conditions. He assumed I would just skim the summary, get intimidated by the legal speak, and rule in his favor to keep the docket moving. He thought I was a joke, but as I looked down at the thick binder of documents he had confidently submitted as his defense, I noticed something buried deep within the third appendix, a detail so small, yet so utterly devastating, that I knew exactly how this hearing was going to end before he even opened his mouth. Funhai, the hearing began, and Richard practically leaped to the microphone. He didn't just speak, he performed. He launched into a highly rehearsed, rapid-fire monologue filled with complicated industry jargon, amortization schedules, depreciation margins, default penalty clauses, and compound interest metrics. According to his narrative, Eleanor Vance had leased a mid-sized sedan from his company, missed 2 monthly payments, and subsequently owed him a staggering $24,000 in early termination fees, vehicle recovery costs, and accumulated penalties. To the untrained ear, he sounded professional, authoritative, and entirely justified. I watched him pace slightly behind his podium, his hands gesturing expansively as he laid out his timeline. This is a classic courtroom tactic. Scammers who operate on paper rely heavily on speed and confusion. They use a barrage of complex legal terminology to overwhelm their victims, making them feel uneducated, trapped, and utterly helpless. Richard had clearly used this exact presentation dozens of times before to bully vulnerable people into submission. He spoke so fast and with such conviction that Eleanor couldn't even formulate a protest. She just sat there quietly, her shoulders sinking lower with every word he spoke, tears pooling in the corners of her eyes. She genuinely believed her financial life was permanently ruined. Richard proudly directed my attention to the massive binder he had submitted into evidence. "Your Honor," he said, adjusting his expensive silk tie with a smug grin, "the terms are explicitly outlined in the contract Miss Vance willingly signed. Every penalty listed is standard industry practice. As a responsible business owner, I must enforce these agreements, regardless of a client's personal financial mismanagement." He used the word willingly with a sickening emphasis, trying to paint himself as the rational, law-abiding businessman and her as a careless liability. He was carefully establishing a narrative of his own absolute superiority. I let him speak. I didn't interrupt. Over the years, I have learned a very valuable lesson. If you give an arrogant man an uninterrupted floor, he will happily expose his true nature. He thought my silence was agreement. He mistook my patience for ignorance. He assumed that because I wasn't aggressively challenging him yet, I was easily convinced by his glossy paperwork and booming voice. As he continued to build his magnificent house of cards, bragging loudly about his meticulous record-keeping and his bulletproof contracts, my eyes were locked firmly onto the single document buried in Appendix 3, the one document he had somehow forgotten to sanitize. "Is there anything else you would like to add, Mr. Sterling?" I asked, my voice completely devoid of emotion. Richard leaned on the podium, looking incredibly pleased with himself. No, Your Honor, the contract is ironclad. The math is undeniable. I simply want what my company is legally owed. He gave Eleanor a patronizing glance, sighing softly. It's unfortunate, truly, but business is business. I slowly turned my attention to the plaintiff's table. When I spoke to Eleanor, I deliberately softened my tone. In a courtroom, the way a judge addresses the parties sets the atmosphere, and I wanted Richard to feel the shift in the room's temperature. Mrs. Vance, I said gently, Mr. Sterling claims you willingly signed an agreement knowing that a 2-week delay in payment would trigger a 300% penalty rate and immediate vehicle repossession. Is that true? Eleanor's voice shook as she leaned into the microphone. No, Your Honor. I fell behind because of my late husband's outstanding medical bills, but when I leased the car, Mr. Sterling personally sat with me in his office. He promised me there was a 30-day grace period for seniors. He said it was a special community program. I wouldn't have signed otherwise. Richard let out an exaggerated theatrical groan, rolling his eyes for the gallery. Your Honor, please. Verbal hearsay. What matters is the ink on the paper. I cannot be held responsible for what a customer claims they heard or how they misinterpreted a friendly conversation. Section 4. Paragraph 2 clearly waives any verbal agreements. He was right about one thing. The ink on the paper usually dictates the outcome, but arrogant people often become so obsessed with building their traps that they forget to check where they are stepping. You are absolutely correct, Mr. Sterling, I said, leaning forward and pulling his massive, perfectly indexed binder toward the center of my bench. The ink is what matters. So, let's look at your ink. I bypassed the highlighted sections he had pointed out and flipped directly to the back of the binder. Appendix 3, a seemingly standard addendum regarding insurance liabilities and vehicle modifications. Richard looked slightly confused, his brow furrowing for a fraction of a second, but he quickly reassembled his smirk. Standard boilerplate, Your Honor. Nothing unusual. Is it? I asked. I looked directly into his eyes, holding his gaze until that manufactured smirk finally began to falter. Because on page 42 of this standard boilerplate, buried in a section about comprehensive coverage, there is a very interesting digital timestamp and an even more interesting IP address log. The courtroom fell dead silent. You could hear the hum of the air conditioning. I watched Richard's posture change in real time. The relaxed, leaning stance vanished. He suddenly stood very straight, his knuckles turning white as he gripped the edges of the podium. He didn't know exactly what I had found yet, but his predator's instinct was finally warning him that he was no longer the one in control. I tapped my pen against the desk, letting the silence stretch just long enough to ensure everyone in the room felt the weight of it. You see, Mr. Sterling, you've submitted a digital copy of the original contract, complete with electronic signatures, a common practice in modern business. I paused, looking directly at him. However, the digital footprint recorded on this specific addendum, the one detailing the 300% penalty rate and immediate vehicle repossession, shows it was created and attached to Mrs. Vance's file 4 days after the lease was finalized. A collective gasp echoed from the gallery. Even my bailiff, who has seen it all, raised an eyebrow. Richard opened his mouth to speak, but no sound came out. His confident demeanor was shattering like a dropped mirror. He tried to quickly shuffle through his own copy of the binder, his hands suddenly clumsy and frantic. And it gets worse, I continued, my voice sharp and unyielding. The IP address logged for that specific modification points directly to a computer registered to your personal office. You didn't just enforce a harsh penalty, Mr. Sterling. You actively altered a legally binding document after the fact, without the client's knowledge or consent, to create a financial trap. Richard's face flushed a deep mottled red. Your Honor, there must be a clerical error, a system glitch. My software provider— Save it, I snapped, cutting him off completely. There are no glitches that maliciously rewrite penalty clauses. You saw a vulnerable, elderly woman struggling with medical debt, and you didn't see a person. You saw an opportunity. You sat in your office, looked at a contract that offered a standard 30-day grace period, and decided to quietly edit the terms to line your own pockets. You built your entire case on a fabricated document, assuming a TV judge wouldn't bother to read the metadata. The courtroom was electric. Mrs. Vance had a hand over her mouth, tears of relief finally falling freely. Richard was gripping the podium so hard I thought it might crack. He had walked in believing he was untouchable, protected by his wealth, his tailored suit, and his complicated jargon. But he had fundamentally misunderstood the nature of the courtroom. Power and privilege can only shield you until the moment the truth is laid bare on the record. Your case is dismissed. With extreme prejudice, I announced, bringing my gavel down with a resounding crack. And Mr. Sterling, I suggest you contact a very good defense attorney because I am forwarding this entire file, complete with the metadata logs, to the district attorney's office for a formal investigation into fraud and document forgery. He stood there, completely destroyed by his own hubris, as I moved on to the next case. He thought he could outsmart everyone, but in the end, it was his own ironclad paperwork that sealed his fate. Most people, when caught in a lie of that magnitude, shrink. They lower their heads, apologize, or scramble out of the courtroom as fast as their legs can carry them. But Richard Sterling was not most people. His arrogance was not just a shield, it was his entire identity. When I struck the gavel and announced that his files were going to the district attorney, the courtroom held its breath. I expected him to pack up his meticulously forged binder and retreat. Instead, he did something that sealed his fate permanently. He slammed both hands onto the podium, his face contorted in absolute fury. The polished, sophisticated businessman vanished, replaced by a desperate, cornered predator. "You cannot do this," he shouted, his voice echoing off the high ceilings. "That car belongs to my company. She is a thief. You are protecting a thief over a legitimate business owner because she squeezed out a few fake tears." My bailiff immediately took a step forward, his hand resting on his utility belt. The gallery, already stunned by the digital evidence, let out a collective murmur of shock. Eleanor physically recoiled, pulling her worn cardigan tighter around her shoulders as if to protect herself from his verbal assault. "Mr. Sterling," I said, my voice dangerously low, "you are currently standing in a court of law, having just been caught committing blatant document forgery. I strongly advise you to lower your voice and step back from that podium before I add a contempt charge to your growing list of legal problems." But arrogance is a blinding disease. He pointed a trembling finger at Eleanor. "She owes me that money. I have an empire to run. I don't have time for this circus. You're a joke. You don't understand how real business works." He was spiraling. When their carefully constructed reality shatters, narcissists will always attack the authority figure holding the mirror. They think that if they yell loudly enough, the facts will simply disappear. "Bailiff," I said calmly, never breaking eye contact with Richard, "take Mr. Sterling into custody for direct contempt of court." The color drained from Richard's face instantly. The reality of the situation finally pierced through his delusion. The metal handcuffs made a sharp clink as the bailiff secured his wrists behind his back. But just as Richard was being turned toward the holding cell, the heavy wooden doors at the back of the courtroom swung open. A man in a sharp gray suit stepped inside, holding a thick briefcase. He didn't look like a spectator. He looked like someone who had been waiting patiently for a very long time. "Your Honor, if it pleases the court," the man called out, walking down the center aisle with absolute authority, "I am Investigator Miller with the State Consumer Protection Bureau, and I believe I have some additional context regarding Mr. Sterling's empire." "Investigator Miller," I said, gesturing for him to approach the witness stand, my eyes never leaving the handcuffed defendant. "You have excellent timing. Please, state your business for the record." Miller was a man who moved with the quiet efficiency of someone accustomed to unearthing buried secrets. He took the oath, set his heavy briefcase on the stand, and clicked the latches open. Inside were stacks of manila folders, so chillingly identical. "Your Honor," Miller began, his voice projecting clearly across the utterly silent courtroom. "The State Consumer Protection Bureau has been quietly investigating Mr. Sterling's boutique auto leasing firm for the past 8 months. Mrs. Vance's case is not an isolated incident. It is, in fact, the foundation of his entire business model." I glanced over at Richard. The bailiff had paused near the exit, keeping a firm, unyielding grip on the defendant. Richard looked physically ill. The aggressive, shouting narcissist from just moments ago had completely vanished. His eyes darted frantically between Miller's open briefcase and the heavy wooden doors, realizing that the walls were rapidly closing in. "Explain," I instructed, my voice echoing the gravity of the accusation. Miller pulled out a thick stack of printed metadata logs. "Mr. Sterling operates by aggressively targeting elderly citizens on fixed incomes. He specifically identifies individuals with recent, severe financial hardships, medical debt, loss of a spouse, fixed pensions, and offers them specialized lease agreements with a verbal promise of extended grace periods. However, our forensic accounting team has uncovered a deeply disturbing, systemic pattern. In over 42 separate cases, Ms. Sterling's office has digitally altered the contracts post-signature, retroactively inserting predatory early termination fees, exorbitant daily penalty rates, and immediate repossession clauses. A furious wave of whispers erupted from the gallery. 42 victims, 42 vulnerable people just like Eleanor Vance, who had been systematically hunted, lied to, and financially devastated by a man who hid his cruelty behind expensive silk ties and complex legal jargon. He waits for them to miss a payment, often a payment they fully believed they had a grace period for, Miller continued, his tone clinical but absolutely devastating. Then, he triggers the altered penalty clauses, repossesses the vehicle, and sues them for the manufactured, massively inflated debt. He has been using the state court system to launder his extortion. I looked down from the bench at Eleanor Vance. She was openly weeping, but the tears were no longer born of fear or shame. They were tears of absolute vindication. For months, Richard Sterling had made her feel foolish, irresponsible, and entirely alone. Now, the absolute truth was out in the open, verified by the state itself. She was not a careless debtor. She was the survivor of a highly sophisticated, predatory scheme, and the man who had callously tormented her was standing in handcuffs, completely stripped of his power and his dignity. The revelation hung in the air like a physical weight. 42 victims, 42 elderly citizens, many likely sitting at their own kitchen tables at that very moment, agonizing over manufactured debts they didn't actually owe, believing they had simply been foolish or careless. I looked from Investigator Miller back to Richard Sterling, the man who had strutted into my courtroom 30 minutes earlier, draped in the armor of a wealthy, untouchable corporate executive, was now trembling so violently that the metallic clink of his handcuffs echoed softly against the wooden defense table. The Bureau has already secured emergency injunctions to freeze the assets of Mr. Sterling's leasing company, Your Honor, Miller continued, handing a formal, sealed document up to my clerk. We have also dispatched agents to his corporate offices this morning to secure the servers before any further digital alterations can be executed. What he attempted to do to Mrs. Vance today was merely the final piece of the puzzle we needed to execute the warrants. His appearance in your courtroom, attempting to use the state's legal system to legitimize a fraudulent debt, constitutes a felony abuse of the judicial process. In my decades on the bench, I have seen every variety of theft. I have seen crimes of passion, crimes of desperation, and crimes of sheer stupidity. But the crimes that truly turn my stomach are the ones executed with a fountain pen and a calculator by people who believe their victims are simply too weak or too uneducated to fight back. Richard Sterling had built an empire by calculating exactly how much pressure he could apply to a grieving widow or a struggling pensioner before they simply gave up and surrendered their remaining assets. He didn't use a weapon. He used intimidation, shame, and a deliberately confusing maze of legal jargon. I turned my gaze back to Eleanor. Her attorney, a young public defender who had taken the case pro bono, was gently holding her shoulder. Eleanor was no longer the fragile, defeated woman who had walked through the double doors that morning. The crushing burden of guilt she had been carrying, the belief that she had ruined her own financial stability through sheer incompetence, was entirely gone. She sat up straighter, her eyes clear and focused, watching the man who had tormented her finally face the absolute reality of his actions. "Mr. Sterling," I said, breaking the silence and forcing his panicked eyes back up to the bench. "You came in here today expecting a rubber stamp. You expected me to glance at your perfectly manicured summary, ignore the fine print, and help you finalize the robbery of a 68-year-old widow. You thought you could use this courtroom as a weapon." I leaned forward, my voice cold and absolute. But a courtroom is not a weapon for the privileged. It is a shield for the vulnerable. And today, your shield just shattered. The heavy wooden doors of the courtroom swung shut as my bailiff escorted Richard Sterling out. The silence that followed was entirely different from the tense, suffocating quiet of the hearing's opening. This was the profound, settling silence of justice finally taking its rightful place. I watched Eleanor Vance stand up, supported by her young public defender. She didn't look back at the doors where her tormentor had vanished. She didn't need to. Her nightmare was officially over. With the state's injunction in place, her fraudulent debt was erased, and the criminal investigation would soon ensure that she, along with the 41 other victims, would receive full restitution from the seized assets of Sterling's dismantled empire. Before she left, Eleanor looked up at the bench. She didn't have to say a single word. The immense gratitude in her tear-filled eyes spoke volumes. That look is the exact reason I have spent more than 2 decades wearing this black robe. It is a constant reminder that the law, when applied with patience and absolute precision, has the power to restore dignity to those who have had it brutally stripped away. In the months that followed, the state dismantled Richard's boutique auto leasing firm piece by piece. The digital footprint he foolishly believed was untraceable became the very roadmap prosecutors used to secure multiple felony convictions. He traded his tailored Navy suits for a state-issued uniform, finally learning that a contract built on deception is nothing more than a confession waiting to be read. He had weaponized his wealth and his supposed intellect, but the system he tried to manipulate ultimately held him fully accountable. People often ask me if dealing with arrogant, entitled individuals every day exhausts me. The truth is, it doesn't. Cases like this one actually give me hope, because arrogant people fundamentally misunderstand the nature of power. They believe power is a loud voice, a heavy wallet, or an intimidating presence. But true power is quiet. True power is the meticulous collection of facts, the unwavering application of the truth, and the absolute certainty that character is the only thing that remains when privilege inevitably collapses. Richard Sterling walked into my courtroom completely convinced that I was just a TV judge who wouldn't bother to read the fine print. He thought his expensive facade made him untouchable. By the time he left in handcuffs, he finally understood that reality does not negotiate with arrogance. Power was never meant to be a shield for the corrupt. And in my courtroom, the truth always has the final word.